Welcome to Sakshi TV's special immigration show with attorney Ms. Prashanthi Reddy from Law Offices of Prashanthi Reddy, PLCC. Please note that Sakshi TV now has 3 immigration shows every week. On Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesday at 5:30 p.m. EST with attorney Prashanthi Reddy in English, and on Friday at 6 p.m. EST with Bhanu Alindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Prashanthi Reddy needs no introduction, but if you need consultation, please log on to reddesq.com for contact information. When you connect with them, don't forget to mention Sakshi TV. From the beginning, reddesq.com has put a wealth of information and online tools in the hands of immigrant community and for benefit of US employers. The reddesq.com site provides you with the latest and cutting-edge information on US immigration law and policies explained in terms you don't have to be a lawyer to understand. Hello, Ms. Prashanthi. How are you?
I'm good, Tarani. How are you?
I'm great. Thank you. So, should we get started with the show?
Absolutely.
Right. Can you please update us with the October visa bulletin?
Yes. So, I was looking forward to the show today because there's a lot to talk about, and hopefully we'll have some interesting calls as well. But we do have a lot of interesting questions to be answered for all of you. The topic itself is so interesting because we're talking about 485s and which is, of perennial interest to everyone. And we're talking about the October visa bulletin, which is not necessarily happy news, but it is definitely interesting news. So to start off with the October visa bulletin, we knew last month itself that things would not be as they promised. The Department of State has been saying over and over again that there are 150,000 extra visas available this year, the same as last year, in fact more than last year. So we were expecting opening of the floodgates in October, but last month we found out that the dates are not really going to move much, and now we have the actual dates for October. It's good news for some and not so good news for some. So I think it's important that we look at this more closer. So at a glance, basically the USCIS has announced, as always, that they will accept the dates for filing in October. So for those of you who don't know, just to give you a brief intro on that, there are 2 dates in the visa bulletin: final action dates and dates for filing. So usually only final action dates are used in order for a 485 to be filed, to determine the priority date. But come every October, since that's the start of the new fiscal year, they start off the fiscal year by using dates for filing. So that the advantage of dates for filing is the dates are usually ahead. So in the sense that the dates are behind actually. So those people who have older priority dates can file. So usually if you compare the dates for filing with the final action dates, the dates for filing are always better. So they give a more wider scope for people to apply.
Right.
So it's, there's an advantage there. So one thing is dates for filing. The second is EB1 China, EB1 India, both will remain current, which is good news as long as they remain current, because we know previous to that, EB1 India has not been current for many years. EB2 China, final action dates are frozen where they were. EB2 India is also frozen, September 1, 2011. However, dates for filing, there's been a movement for EB2. So it's now July 8, 2012. So that's a movement of about 8 months from last month for dates for filing. So that will open up processing for some, additional candidates, especially for those people whose companies refuse to downgrade their I-140s from EB2 to EB3. There are a lot of multinational companies who just refuse to do that. So this is another opportunity for them, as dates for filing have not been available since last October. So this is the first time they're available again.
Right.
And they're not bad. So, there's a small window of people that will file there. And then again, EB3 final action dates haven't really changed. And the dates for filing have actually retrogressed by 2 months compared to last month. But in general, right now, dates for filing for EB3 is January 8, 2014 for India. And I'm mainly focusing on India because we don't have viewers from China. So I think we need to focus on India. But
Ms.
both
Reddy?
countries are retrogressed. Yes.
Yes, we have a caller waiting. I hate to interrupt you in between, but we have a caller waiting.
No problem at all. Please feel free
Right.
to
So
interrupt.
Mr. Sumant from Maryland is on hold. Thank you for calling, Mr. Sumant. You can ask Ms. Reddy your question directly.
Sure. Thank you so much. Hello, Mr. Reddy. I have one quick question regarding I-485, I-693 medicals. My case, with regards to my case, I actually filed my green card back in 2010. During then, actually, my dates became current, and I have submitted my medicals back then in 2012, April. Unfortunately, the date got retrogressed multiple times, and back in April 2021, when the dates became current, I have submitted new medicals as part of interfiling. Unfortunately, the USCIS did not consider them. I do not know for what reason. But they, in fact, issued an RFE last week asking for submission of new medicals, stating that the existing medicals got expired, and at the same time they also have asked me to submit a biographic information sheet. So I'm wondering, can I probably take a copy from April 2021 and submit it to USCIS, or is it better to submit new medicals again? Since there is a clause in there saying 60 days signed from signed by the physician or something, that itself is causing a little bit of confusion between the communities. So I just wanted to clarify that piece of information.
Right. So a lot of people are trying to file their medicals before they actually ask for them. And that's a gamble always, because it's always USCIS's policy. If they don't ask for something and you send it, they throw it in the garbage. But these are, of course, exceptional circumstances, and we've all been trying to be proactive and submit medicals along with the RFE, even though they didn't ask for the medicals, or submit medicals even without an RFE, just with the receipt notice, and sometimes it has been successful and sometimes not. In your case, unfortunately, not so. So I always do that with some apprehension, because I know it may or may not work. So I'm not surprised that you received an RFE for medicals even though you've submitted them before. Now there are two things. One is we have to make sure that you submit your documents ASAP, because you want your visa number is current. Before September 30th, it would be a good idea if they reserve that visa number for you, so that that you can get your green card. And we know there's retrogression in EB3 likely in November. So you want to make sure you get your medicals in as soon as possible. So what my suggestion is, first of all, you can't submit a copy of the medicals. You have to submit original sealed envelope, right? So my suggestion is go back to the doctor. Most probably he won't have to do, all those tests again, and he can, give you the medicals pretty quickly by just signing it with the current date. Medicals, yes, are good only for 60 days, especially if you're submitting it for the first time. So I suggest that you go back to that doctor and get the medicals done, seal them. It shouldn't take a week. I'm hoping that they can give it to you in a day or two, because maybe a lot of the tests won't be required because they have been done recently. But it just has to be signed with a recent date. So I'm hoping that will work for you, because there is again this urgency to submit, right? Because if your case is document complete, and this is an important part of the conversation we're having today, if it's document complete, that's the only time that they will actually reserve the visa number. So even Charlie Oppenheim today, the person who actually writes the visa bulletin and decides the numbers, has urged people to send in documents ASAP so that a visa number can be requested. So my answer to you is try and you have to get sealed medicals again done. Try to get it ASAP and submit it.
Right. Ms. Reddy, we have another caller waiting. Mr. Sumant from Atlanta. Thank you for calling, Mr. Sumant. You can ask Ms. Reddy your question directly.
I'm from Atlanta. So I have a priority date of 2012 May 14th. So in October 2020, I missed the boat, and in June I got my perm approved through new employer, and I got 140 and 485 done concurrently. So biometrics is done and medicals are submitted and everything is done. So the question is with the today news, right? They are saying that EB3 may retrogress. So my perm is already eligible to file in EB2 and EB3. So should I go to my attorney and ask, please file another EB2 petition or EB2 140,
There's no harm in having an EB2 and an EB3. Everybody is really doing that because it's just the circumstances are forcing us to file, two EB2s. So as long as the labor cert qualifies you for EB2, you can file, as you know, both EB2 and EB3. So you can have two separate petitions, EB2 and EB3. And if the date should retrogress or if EB2 dates become better than EB3, then you can, the final action dates, then you can interfile with that EB2 I-140 that you have. Yes, absolutely. You should go and do that. Go ahead and file another I-140.
Okay, yeah, sure. And one final question is, right, so is there any chance, so I filed it in the Texas Service Center, so can we expect anything by September 30 as we are documentarily complete? So I'm just exaggerating and asking, so.
Right. If your 485 has been filed and your priority date is current, but we don't know whether there'll be an RFE or they require some documents, or if your case is documentarily, complete. We don't know that, right? So if it is, then it's possible that the officer might reserve a visa number for you before it retrogresses. And again, there's no confirmation that it'll retrogress, but basically Charlie says that it might. So we have to presume the worst, unless, of course, there are other competing factors that we have to consider. There's legislation that may be passed, we don't know, with the budget reconciliation bill, which has to be passed before September 30th, right? Before the end of the fiscal year, so that the government doesn't run out of money. They can, of course, postpone it by 1 month or two. But if they do pass that bill, and if they do pass the immigration component of it, which says that unused visa numbers from previous years should be used, etc. And there is another component to that if your priority date is taking over 2 years, then you pay that $5,000, and you can at least file the case. But that's not really useful for you because you've already filed. So yeah, we don't know. The answer to your question is we don't know. If it's documentarily complete, then yeah, if you get lucky, they might just reserve the visa number. But just remember, a lot of people have filed 485s before you, and they're still waiting. So it doesn't look possible. But again, we have confirmation that about 7,000 to 8,000 cases are being processed every month. In September, they processed the highest number of cases, USCIS. So they're trying their best to move cases forward and to request those visa numbers so they don't get wasted. So you never know.
Right. Ms. Reddy, I have a question. Where can one find this visa bulletin?
You should go to travel.state.gov, and then under that just go to visa bulletin, and then you look up, as per your category. There's employment based, there's family based, So you go to your category EB2, EB3, EB1, whatever it is. And usually, as I said, there are two tables. One is dates for filing, one is final action date. USCIS informs us every month which table to look at. And for October, usually every year from October to about January or February up to March, they look at dates for filing. And the rest of the time, it's always final action dates.
Right. And
So as long as you know, yeah.
Yeah,
Go
please
ahead.
go on. Please go on.
As long as you know, you have to look at the right table. But most of our viewers are already very knowledgeable on this. So, I don't think they need any extra guidance on where to look and which table to look at.
Right. So how often does the visa bulletin get updated, or is there a usual time that it only gets updated?
It gets updated every month.
Right. So if
And then you know the month before, by the 15th or so, they will let you know for example, in September we got to know about the October visa bulletin. So they give you advance notice of about 2 weeks to prepare.
Right. So when a person gets their green card, right? So does it mean that their family members automatically get a green card?
No, family members don't automatically get the green card. It's, this misconception is there. Even when people file for a H1, they think automatically the spouse gets a H4, and sometimes they don't file. And the spouse falls out of status, especially in an extension situation. Same thing with the green card. Each individual who wants to file for a green card has to apply for a 485 and has to qualify separately for that 485. It's not simply because the spouse, the principal applicant qualifies that you qualify. It could be that you don't qualify, even though your spouse qualifies. So there is various reasons to disqualify someone and deny the 485.
Right. So what documents should be submitted for the process of I-485?
So there are a lot of documents that have to be submitted.
Right.
But Rani, before I go to that, can I just finish the updates that I was giving on the visa bulletin?
Yes. But before that, I'm very sorry, but we have a caller waiting.
You have a call. Okay, callers are always good. Then I don't have to, talk.
Right. So there is a Mr. Nikhil on the call. Thank you for calling, Mr. Nikhil. You may ask Ms. Reddy your question directly.
Hey, Mr. Reddy, good evening. So my question to you
Hi,
is,
Nikhil.
I'm on an EB2 May 2015 priority, which is quite a bit. Right now it's 2012 based on the visa bulletin, right? So the question here is, do I downgrade? Do we anticipate that because of the spillovers from family-based visa for next year, right? My company is not ready to downgrade for sure, but can I downgrade to a different employer, like just a perm petition to a different employer? That's question number one. And question number two, since it's too far, 2015 May, since EB3 is getting retrogress, do we anticipate based on the spillover for the next whole year, will there be any movement as such up until in 2015? That's the question number two, which I have. Probably if you answer those, that would really help me. Because what I'm trying to do is I'm trying to come up with an employer who can file another downgrade form petition for me. So that's what I'm looking at.
So Nikhil, you're presently EB2, correct?
Yes. Mm-hmm.
And then you couldn't downgrade to EB3, so you're stuck with the EB2.
Yes.
And so you want to find another employer and file another perm and I-140 in EB3. Is that correct?
Correct. Yes.
So basically, you're asking me to predict what will happen with EB2 and what will happen with EB3, and no one can say for sure. And you knew that would be my answer. But
no.
Just to again,
go ahead.
So just to let you know, what the prediction. And again, it may not be correct, but Charlie Oppenheim is the guy who makes these predictions, right? And he's made predictions that have come wrong, and it's from one month to the other, something he says, and people are very disappointed now with the October visa bulletin, because he said EB3 would not retrogress until the end of next year. He said that many times. So, but as per what USCIS and the Department of State is right now saying, is that they don't expect any significant forward movement for any category, first of all, until January. In the January visa bulletin, you might get a clearer picture as to where the numbers will move, how much they'll move, or whether they'll move or not. So the January visa bulletin might give you a better picture of that. You're not expecting any forward movement from now to January. He's made that clear for family-based and employment-based petitions. There was actually, I'm glad you asked this question, because this is something that I wanted to talk about anyway. This is part of my updates for the visa bulletin. So there was a question as to whether March 2014 priority date for EB3 will become current soon. And he said that that's not likely. So you're not likely to even come up to March 2014 for EB3, all of next year, fiscal year. So that's where we stand. EB2, it's hard to say what the movement, there won't be any movement until January after that. It's really hard to say, and basically those questions were not answered. With reference to your comment on spillover of the 150,000, right, from the family-based, what happened to them, and why are more numbers not available, I just want to say that they're now saying that all that spillover of 150,000 visas have been used or have been put into the employment category, but it has still not created a forward movement, because the existing downgrades are so many for India in the month of October, and then consequently moving forward in the following months, that it's enough to make use of the worldwide visa numbers. So you see the predicament. That's why EB3 has to be retrogress. So this is what they're saying now, which is a completely different picture from what they painted previously.
Right. Ms. Reddy, we have another caller waiting, Mr. Mish from Texas. Thank you for calling. You can directly ask Ms. Reddy your question.
Yes, ma'am. This is Vish from Houston. So my priority date is EB3 2013 September, and I had an EB2 petition with another employer, but since EB3 dates are current, so we filed our I-140 with the new employer in EB3, although the firm was qualified for EB2. And that is how I was able to file our 485 as well. So the I-485 is already sent, and now I'm going to probably get an EAD, and since they are trying to move the dates back, I may be stuck with EAD now. And in case EB2 dates move forward, will I be able to file another I-140 and interfile with 485?
Yeah, absolutely, you can. Most people, as I was telling the previous caller, have an EB2 and an EB3 if they can. They keep both I-140s, and then they use the I-140 where the priority date is, the best. So even without you having to interfile, USCIS is supposed to use, if it's from the same employer, if you have two I-140s, they're supposed to use the I-140 automatically, which has a better priority date. So yes, absolutely, you can interfile.
Right.
My EB2 I-140 was with employer A.
If it's with a different employer, then of course, then your 485 is already filed with one particular employer. So you can't switch back and forth. You have to file another I-140 with the same employer.
Right. Ms. Reddy, we have another caller on hold. Miss Vasavi from Atlanta. Thank you for calling, Vasavi. You can ask Ms. Reddy your question directly.
Hi, my name is Vasavi. So I have a question. My father-in-law is in emergency right now. Can my husband travel to India and come back within 1 month because of the travel ban. Is there any issues regarding that?
Yes, there's an issue, right, with travel bans. Unfortunately, it's making people's life really difficult, especially in emergency situations like yours. I'm presuming he's on a H1, or what is your husband's status?
Yeah, he's on H1.
He's on a H1, yeah. So that travel ban, as you know, clearly applies, and they cannot travel unless they qualify under NIE, National Interest Exception. And a lot of people are qualifying under the NIE. So once he goes to India in order to come back, he has to first approach the consulate for an NIE approval. And if that's approved, then he can come in. The other way of coming in, Vasavi, is also, quarantining for 14 days in Mexico or somewhere. And that way also you qualify to come in. That's a loophole with the travel ban.
So he has to apply for NIE for sure, right?
Yes, either NIE or 14 days, go to a third country where there's no travel ban and then come from there.
Okay, okay. So we can apply because if he go and come back, he can go because he's in emergency, but he's not any like a life or death situation. If we are expecting something, maybe if he can go and come back again and he can go, like that's the question.
You mean travel multiple times?
Yeah.
So an NIE can be approved for multiple travel, but it is usually given for a specified period of time, but they can approve it for multiple travel, multiple visits.
Okay. Thank you so much, ma'am.
You're welcome. Take care.
Ms. Reddy, with all due pleasure, please continue with the updates.
Yes, I'm not getting a chance to do my updates this week.
Yes, please go on.
But that's a good thing because then, Yeah,
you have a lot of
it
callers.
makes things less boring.
Right.
A lot of callers is good because
Right.
it's more interesting that way. But so as I was talking about the changes in the visa bulletin, I think during the course of our last few callers, we covered quite a bit with reference to the visa bulletin. I just wanted to cover a few things that today at 1 o'clock, Charlie Oppenheim had a Zoom session where he pretty much explained what's happening. And the additional news is that, as I said, no forward movement in any of the employment-based cases or family-based cases for the next 6 months. Some movement likely in January, but we will know that only in the January visa bulletin. He has explained why retrogression happened with EB3. A lot of people had that question, and rightfully so, because it came as a surprise, because it didn't seem to be that there will be a retrogression previously. And his explanation was basically that, first of all, a lot of cases were processed in the month of September by USCIS, and they have been processing about 7,000 to 8,000 cases a month. So the demand has increased unexpectedly because of their speedy processing. They seem to have woken up suddenly. So that's why the visa numbers are being requested and are being used, and there's a demand, and therefore, when there's more demand, then there's less supply because there's a limited number of visa numbers. So that's how he has basically justified the fact that there's no forward movement. And with reference to the spillover, he's saying that the spillover is being used for the existing cases that are now being processed by USCIS, which were filed in October of last year. He's saying that is enough to cover the 150,000 spillover as well. And then what else? I think that's about it. I think we can go to the questions now if we have any.
So I asked you what kind of documents do we need to submit for the I-485?
Yes, you did, and I didn't answer that question, but I will now. The 485 documents are They're in a few categories actually. You have to submit documents to show your nationality. You have to submit documents to show your identity, to show your country of birth. If you have any criminal record, you have to show documents to show your status in this country. You have to show, not now, but previously you had to show documents to show that you would not be a public charge. But luckily, that public charge rule has gone away, thank God, because last October we filed like 500 pages of public charge documentation on each case, but we don't have to worry about that anymore. So it's basically you're talking about along with the forms, you're submitting your birth certificate, you're submitting all your approvals to show that you have always maintained status in the US. You're submitting all your I-94s. If you're married, proof of relationship. If you're filing for your spouse or child, you have to submit the marriage certificate and their birth certificates. And then if you're on a H1, then proof of status. Anything needs proof of status, no matter which status you're in. A H1 would require a 797 approval and pay stubs to show that you're actually being paid by the employer.
Right.
So these are some of the documents that are needed.
Right. Ms. Prashanthi, we have a caller on hold. Mr. Sunny from Portland, thank you for calling. You can ask Ms. Reddy your question directly.
So, Ms. Reddy, so my question is regarding the new bill, that reconciliation bill. Is that a good time to ask you on the question on that?
You can ask me a question, I'll answer if I can.
Yeah, sure. Actually, there is a lot of buzz going on this new reconciliation bill, right? So what are the hopes? Like, it is giving a lot of hope for the, GC dreamers. So what is your view or advice or opinion on that? What is the hope that become a law?
The thing is now with the way events have gone, especially with the visa numbers, the number of bills that were introduced and almost got passed but never got passed, now I think people are a little tired and they don't get their hopes up until they actually hear some good news. So, I will just wait and watch. We don't know. See, always the DREAM Act is the first priority. So they have that's part of the bill. So that has no opposition. So the DREAM Act or some components of it will be passed, but that does not help, obviously, DV applicants. There are different parts, right, to the bill, the different features to it. Some are more likely to be passed and some less likely. The one that we can talk about is using the unused visa numbers. I don't think anyone has anything against that because they're not actually changing the law. There's a problem with changing the law and removing country quotas because then the worry is that India and China will pretty much monopolize all the green card filings because they have a higher volume, and that's a big worry for people. So it's difficult. Maybe they won't agree to that, but removing completely the cap on numbers is the best thing to do because then no one is harmed. Everybody has numbers freely available, but then again you will have the anti-immigrant people who are not for that also. So people who don't want a free reign in who gets a green card, so there'll always be opposition to that. There's another new proposal, as you know, about if it's more than 2 years, if you have to wait for more than 2 years for your visa number to become available, then you pay that $5,000 or $2,500 or whatever it is, and you can file the green card. That's pretty much as good as eliminating the cap. So I don't know, but it does bring in a lot of revenue. If you're a family of four, $20,000 to the USCIS and to the federal government, but you might find opposition to that as well. So these, I can only give my comments and talk about each the different legislations that are there right now, but we can't predict what will happen. Let's wait until the end of the month to see if anything will happen or it will get postponed. That also is possible.
Right. Ms. Reddy, we have another caller on hold, Mr. Yuvraj from Georgia. Thank you for calling, Mr. Yuvraj. You can ask Ms. Reddy your question directly.
Yeah, hi ma'am. My name is Yuvraj, and so what would be the fees for? Sorry, I joined late. You maybe explained this already, but I just wanted to know that the fee structure for the primary and the dependent.
The 485 USCIS charges $12.25 for the fee.
Okay.
So that's the USCIS charge.
If the new amendment that it will take in action, so what would be that?
We don't know. There's a proposal of 5,000. There's a proposal that of 2,500 and 1,500. So there are different proposals. So we don't know what will actually get passed. But the proposal is that it'll be 5,000 per applicant. So if you have 4 applicants, then you'll have to pay USCIS 20,000 to file the 485. So you can actually file the 485, but you will not get an actual green card, but at least you'll have the benefit of filing. And that's there's a lot of benefit to that, because then you're not dependent on your H1. You can go on 485 EAD and you can change jobs. You have more flexibility for travel also.
Oh, okay. So once we get that 485, then I am free from going for H1B or
correct, going for your visas and filing amendments each time you change location. So all that is very burdensome every time you have to file.
Right. Ms. Reddy, another caller on hold. We have Mr. Kiran from Dallas. Yeah. Thank you for calling, Mr. Kiran. You can ask Ms. Reddy the question directly.
Yes, ma'am. So I got my EAD based on my EB3 petition, but the question is, my H1B is on chemical. I'm a chemical engineer, and my H1B is a chemical engineer H1B. But the job offer was a software developer, which required 6 months of experience, and which I had back in my OPT time. That is how we utilized that, and we got I-140 approved as a software developer. So now, on this, using this EAD, can I take up chemical engineering jobs or no?
So you are talking about AC-21. You're talking about the law which allows you to port employers, right?
Yes.
6 months after the filing of the 485 or the approval of the I-140. So part of that job, part of the law with reference to AC-21 states that yes, you can transfer employers, but it has to be a same or similar job in order to transfer. You can't work as an accountant and then work as a lawyer. That's a drastic example, but just to make it easy to understand. Now, in your case, if your job was approved as a software engineer or an IT person, and you're now working as a chemical engineer, in my opinion, I don't think it's same. It's definitely not same, but it's not similar also. I would go as far as categorizing everything within the IT field as similar, but if it is outside of that field, like you're working as a mechanical engineer or a chemical engineer, electrical engineer is a little closer, but still, it's a different job. So, in my opinion, I don't think that AC-21, when you file the 485J, it will get approved.
No, but if the date becomes current again after 10 years, at that time, if I have a job offer in the same field, will that not be sufficient? Like now, all these 10 years from now to another 10 years, I have to work as a software developer?
Correct, because you have to maintain at any given point of time, you have to have a valid job offer. Okay, let's just put it that way, a valid job offer. So you don't have to actually work for the employer, but you have to have an offer of employment from the employer, right? So if you're going to move to a different employer, but the offer of employment is still open with your previous employer, then you might be okay. But USCIS will come back and question why you did not work for that employer, why you left that employer and joined another employer, even though it's a future job offer and allows you don't have to work as per regulation, but the question of a bona fide offer of employment will come up. And they'll ask you, you could have worked on an EAD, why didn't you? How do we know you'll actually work after you get the green card? How do we know it's a bona fide job offer? So these questions come up which you then have to deal with if you're not going to be working for that employer. But at any given point of time, you don't have to be actually working, but you have to have an offer of employment and you have to face the bona fide job offer questions that they might have. I hope I'm clear.
I'm sure you are. We have another caller on hold, Mr. Nagesh from Florida. Thank you for calling, Mr. Nagesh. You may ask your question.
Yeah, hello Prashanthi. Hope you are doing well. I have a question around
Hi,
on
Nagesh.
H1B.
Okay.
Oh yeah, I have a question on H1B. Is it legal to accept any advisory roles while being on H1B for the abroad offers like Hong Kong or company from Hong Kong or India? If they are offering any advisory role, is it okay to accept
as long
such roles?
Or are you getting paid or not? There are a couple of questions that you have to ask. Is it a US-based company or it's not? Number one question.
It's not a US based. It's based out of
So
India
then
and Hong Kong.
If it's not a US-based company and you're not getting paid in the US, then it should be okay.
But I would be getting paid in India. Is it fully okay?
That's fine. Yeah.
Okay. Sounds good. Thank you.
You're welcome.
Right. So I have another question for you. When does one take the medical exam?
So a medical has to be taken 60 days before at least a maximum of 60 days before filing of the application. So it cannot be more than 60 days because then it becomes invalid. So make sure that you don't do it too quickly as well. And an update on that, which I forgot to mention previously. Now USCIS is saying that you have to take the COVID-19 vaccine as part of the medical test. So that's brand new breaking news for all of you out there. Anybody filing a 485, if you haven't taken your COVID-19 vaccine, now you are forced to because they won't approve your 485 without that. That is part of the medical exam. So the doctor will not even conduct the medical exam and give you your envelope without you showing him the proof of vaccination.
Right. Ms. Reddy, could you please explain to us what an EAD is and when does a person apply for it?
An EAD is employment authorization document. That's short for EAD. We use a lot of acronyms in the world of USCIS. You apply for it when you file the 485. So it's incidental benefit that you get. The two benefits that you get by filing a 485, which is why it's great to file a 485 and be able to file one, even if you don't get the green card immediately, is the employment authorization document and the advance parole. The employment authorization document allows you to work in the US. You of course have to work for your petitioning employer because of what I discussed earlier about bona fide job offer, etc., etc.
Yeah.
But it also allows you to work for other employers. As long as you're working and maintaining your green card status, you can also have two employers. It's not like the H1. EAD is not like a H1 where it's restricted to the employer that filed the H1.
Right.
And it doesn't have all those, terms and conditions of a H1, the prevailing wage. You have to be paid a certain wage. You have to amend the petition every time something changes. It has a lot more flexibility, the EAD. So that's why that is always preferred medium of work when compared to the H1.
Okay. So, but does the EAD void the H1B in any way?
So, yes, if you you can't be in two statuses at the same time, right? That is a golden rule of USCIS. You only have one status at a given time.
Yeah.
So if you are on EAD, that means that you're no longer on a H1. So if you filed a 485 and you don't use your EAD, then you can continue to maintain your H1 status. But once you use your EAD, that means you're only in pending 485 status. And in order to get back on a H1B, you can't do a change of status. You have to actually leave the country and come back on a H1B visa to get back on a H1. So that's one of the interesting things about using an EAD.
Right. We have another caller in line, Mr. Kumar from Dallas. Thank you for calling, Mr. Kumar. You can ask Ms. Reddy your question directly.
Anti Reddy garu, this is Kumar from Dallas. My
Hello,
question
Andy.
is like, hello. My question is like, currently in EB3, my date became current as per the last bulletin. So I'm applying my downgrading from EB2 to EB3 process with my old employer. But I'm hearing that in next bulletin, there might be some retrogression happening for the EB3. So do you recommend, should I wait for to see another bulletin before going ahead, or what is your recommendation on that one?
I think one bird in hand is worth more than two in the bush, right? Which basically means that you have to take what you have now, because you cannot presume that the visa numbers will continue to be current in November, or that they will become better. Based on what the Department of State is telling us, there's not going to be any forward movement in EB2 or EB3, but there will be a retrogression in November unless something happens for EB3, which means that in October, if the dates are good for you, then you're able to file, then you should file. There is no question about it. Now later on, if dates become, EB2 becomes better, then there's nothing stopping you from filing an EB2. So yeah, I would suggest that you file the 485 if you're able to next month, if the visa numbers. Don't wait and hope for things to get better. Then you'll lose what you have also.
Right.
Okay.
Ms. Reddy, could you explain to us what an RFE is?
Yes, so very important now to talk about 485 RFEs, which is another acronym, which is a request for further evidence. So why it's important is because for all those folks out there who filed their 485 in October, now we are getting RFEs, or we have been for the past couple of months. And it's important to be able to respond to these RFEs in a timely manner. And again, we talked about that because the visa numbers will not always be available. So while before the end of the fiscal year, if you do have an RFE, try to respond to it ASAP. If you have other competing concerns, I think this one is the most important. So you do respond, don't delay on your RFEs. That's one bit of advice I wanted to give on RFE, but that doesn't necessarily explain what an RFE is. An RFE is a request for further evidence which is sent by USCIS. If there are some documents or some questions that they have, they send out these notices, and there's usually a deadline to respond to these notices. The maximum time given is 84 days, I believe. So you can, again, don't use that entire time. But usually the requests for further evidence they ask, the most commonly found RFEs are those asking for medicals, because in October a lot of people did not file with medicals, they just filed without that, and I think that was a bad idea, because now your visa number might be current, but the officer cannot reserve the number for you because you're still waiting for a medical RFE, because your documents are not complete. Your case is not complete, so they can't reserve the number. So the most common RFE is for medicals. There's also the second most common RFE is for some questions that they have on the birth certificate. Sometimes 485s are sent without birth certificates. Sometimes they are birth certificates which are registered late, and and therefore they send out RFEs for secondary evidence of your birth. For Indians, mainly they're asking for school leaving certificates, and they're asking for affidavits from people who knew you at the time of your birth, who were present at the time of your birth, to attest that you were born on so and so day, so and so time.
Right.
So that's how, yeah.
Yes, so we have another caller on hold, Mr. Damodar. Thank you for calling, Mr. Damodar. You may ask Ms. Reddy your question directly.
Hi, ma'am.
Hello.
Hello. Hi, ma'am. Actually, my priority date is February 2013. So right now, I'm downgrading my 140 to EB3. My question is, now once I apply for downgrade to EB3, and for some reason my EB2 becomes current, and here my EB3 140 is still pending, means if it is not approved, in that case what I can do? Can I go out again apply in EB2?
So what is your fact scenario? You're saying you're filing for a downgrade and filing for 485 because your date is current, right? And you're saying that while it's
current in EB3, so I am downgrading to EB3 now. I have to downgrade.
Right. So yes, you can go ahead and do that. And your question is, while your I-140 is pending, what happens if the dates move again, right?
EB2
is that your
becomes
question?
current. Yeah,
Right.
when my 140
then,
is still pending in EB3, if my EB2 date becomes current, what should I do? Can I apply again EB2?
Yes, you can, because as long as you qualify for EB2, you can only, it's called an upgrading rather than downgrading, but you can upgrade your I-140 to EB2 provided your labor cert supports it. So your labor cert should, the job in your labor cert should require a bachelor's plus 5 years or a master's. If it does require that advanced degree, then you qualify for both EB2 and EB3. So if you're choosing EB3 now and your I-140 is pending, you can always file another I-140 while this I-140 is pending with a copy of the labor cert. The only thing is you may not be able to file premium processing, but you can file another I-140 and use the I-140 that is more conducive to you.
Right. Ms. Reddy, my question is, what kind of I-485 RFEs are we looking at right now?
So as I said, that's what we were talking about. But they're basically asking for birth certificates. They're asking for medicals. They're asking sometimes if there's an arrest. I mean, always when there's an arrest, they'll send an RFE because they want original court documents. And, you know, there are a lot of petty offenses that Indians commit also. They don't go for the big crimes, but there are a lot of petty offenses that you'll be surprised. There's shoplifting, there's traffic related violations, not traffic violations where you get a ticket, but actually, you know, DUI and things like that. So whenever that happens, they always want to make sure that you have met all the requirements towards, you know, that you're sentencing, or if, you know, so if it's a misdemeanor, that is still an exception, but if it's a felony, then you might be precluded from getting your 485. So, you know, that's one thing they always send an RFE for.
Right.
Sometimes it's just, you know, you don't provide proper documentation and they could send an RFE there as well.
Right. So we have a caller on hold, Mr. Malesh from New Jersey. Thank you for calling, Mr. Malesh. You may ask Ms. Reddy your question directly.
Reddy, good evening. This is Maleshwar. Yeah, I have a question for you. I have applied my EB3 on green card, and then it was current last year. And one question for you is, my daughter is aged out. She's over 21 years now. So is there any way I can get a green card for her, or she has to go the same story what I went in last 10, 15 years?
Yeah, it's very sad, especially for kids who've aged out. It's bad enough that you had to wait for so many years to get your green card, while others are getting it faster than you. The children who really have lived here all their lives, or most of their lives, are then again being forced to go through the entire process again. So unless your child qualifies under CSPA, Child Citizen Protection Act, which is really a very narrow benefit because from your child's age, it deducts the time that it took for your I-140 to get approved, which is not very long because, I-140 is premium processing. It doesn't take more than 4 to 6 months, even if it isn't. Maximum a year. So that's the only benefit that you have. Unless some new law comes out, and I'm hopeful that at least for aging out children, there'll be some, legislative relief. But until then, they have to move to an F1, which I'm sure, they must have already done, and then follow the process of going to a H1 and then a green card.
Where I can apply once I got my green card, can I apply green card for her?
Yes, of course. Yeah. But then it takes you can. Yeah, you can. I'm sorry, I forgot to mention that. Family-based petition, you can file an I-130 and a 485 once the visa number becomes available. But, the wait is long for those categories because it's an adult child, and then once they get married child over 21, the wait is even longer. So, again, unless something happens with the family-based petitions, but there's no harm in doing an I-130. And but if they're on an F1, remember, again, you don't want to file an I-130. But of course, you can't right now unless you become a U.S. citizen. So that's some ways off. But yes, that's definitely one benefit, an additional benefit that they have.
Right. Thank you so much, Ms. Prashanthi Reddy, for sharing with us your wonderful insights and wealth of information with us and our viewers. It was a privilege hosting you.
It was fun, Tarani. Hopefully, we'll see each other next week, and I'm looking forward to talking to the viewers next week as well.
Same here. Thank you so much. You're watching Sakshi TV Live with me, Torini Mokana.